What should you look for when choosing a beneficiary? So my name is Rex Crandell. I'm a CPA and attorney, real estate broker in Walnut Creek, California. I have a small practice there. The question today is, what should you look for in choosing a beneficiary? First of all, we need to determine what is a beneficiary. So the definition is it's a person who will receive assets or something of value after you pass away. And that could be tangible assets, real estate, personal property, or intangible assets, stock certificates, copyrights, patents, those kinds of things. First, when I think about picking beneficiaries, imagine yourself getting ready for Christmas, and who are you going to buy presents for? Well, that's a good indication of who you might want to have as your beneficiaries, because Christmas is a once a year event and people want to make other people happy by giving them gifts, and bequesting assets is a once in a lifetime situation. So it's another time where you can look at it like Christmas and making people happy with the gifts. Some types of beneficiaries. One is called the primary beneficiary. So you've identified something that this particular person's going to get. And if they're not around or don't want that item, then there's a contingent beneficiary, an alternate, so to speak. And in most estate plans, there's also what we call residual beneficiaries. And it's kind of a catch-all in case some of the other assets escaped without being designated. And the residual beneficiaries are determined by each individual state's intestate succession rules. Individual beneficiaries can be individuals, groups, like Lions Rotary Club. They could be nonprofits like Animal Rescue Foundation, Cancer Society, that kind of thing, and also religious organizations. One factor to consider is who is financially dependent on you. If you have young children, you need to consider their dependence, and you might want to supplement a gift to them to maintain their lifestyle should you pass away by adding in term life insurance to help get cash for their future. Another factor is, are you married or partnered? That would be another thing to look at. What are your spouse's needs for finances? Consider whether you have children, grandchildren, nieces, or nephews who might benefit from your assets. Look at what promises you made. Did you agree to pay your parents' medical bills? Did you agree to pay your niece's education costs? And if your beneficiary is under age 18, in California, they cannot receive directly more than $5,000. If any minor under age 18 receives that amount of money, they just can't hold it. They have to have either a guardian, a parent or guardian, and a guardian of the estate if it's in a court proceeding. Another thing you can do for minors is give a 529 plan to them, which is contributions to an education fund. Another item can be considered for minors is a Uniform Gift to Minors Act form, but when they become age 18, the minor can take the money out and spend it and buy cars, entertainment, and waste the rest. You can keep money in your trust for a minor until they become any age. Frequently, I see a third of the assets at age 25, a third at age 30, and a third at age 35 to let the beneficiary get used to handling large sums of money. Another thing you can give to for a minor is a method is called a blocked account. And we get into blocked accounts normally in probate proceedings. Employer sponsored pension plans have some unique characteristics. If your employer has a 401k or a 403b pension plan, you cannot give that a beneficiary statement to anyone other than your spouse without the spouse signing that they agree to that. It's just a requirement under the ERISA law. And that requirement does not apply if it's an IRA or a Roth IRA. Other beneficiary characteristics, people think that everything goes by will or all the assets will pass by trust. That's not the case. Certain assets like life insurance, annuities, IRA accounts, Roth IRAs, you have a contract with the vendor. And that contract, usually called the beneficiary statement, and your will and trust has no impact on your contract with the vendor. One thing you can do if you want those assets to go into your trust is you could name the trust as a beneficiary, but there are some pitfalls in naming your trust as a beneficiary if you have pension plans, and that is an individual recipient or individuals can roll over the funds into a rollover IRA and claim tax benefits, like not having to pay tax on the distribution all at once, where if you designate your trust as the beneficiary, that right disappears. So you can make gifts through a will, and generally if it's over $166,250 now, that has to be probated before it's distributed. You can make gifts through trusts. And for minor children, people that are not able to handle large sums of money, if they're disabled or chemical dependent, you might consider setting up a special needs trust to protect government benefits, or to allow for time for the person to become not so much of a spendthrift, let's say a child at age 25 when you distribute the gift. So those are some of the factors you might want to consider in naming your beneficiaries.